Yes, Lordship.
Yes.
Lordship, I beg to mention item number 26.
26.
Here, leading counsel Mr. K. Lawley is out of his station, Lordship. Leading counsel Mr. K. Lawley is out of his station.
Where is the other side? What's there?
Yes, I have taken consent from other side.
You are for respondent.
Yes, Lordship.
Where's the petitioner?
No problem.
When do you want?
3 weeks.
2 weeks. Mister, your name? Name, please.
Jeetai, Lordship.
Huh?
Jeetai, Galitai.
Mr. G. Learned Counsel appearing on behalf of Mr. K. Lawley, Learned Counsel appearing for the respondent. Submits that Mr. K. Lawley, who is leading counsel in this matter, has some personal difficulty. Therefore, for which he prays for listing the matter after 3 weeks. Please note, prayer dialogue, list this matter after 3 weeks.
Deeply obliged.
May I, Lordship? I am representing from the respondent. I beg to mention item number 6. Matter may be listed after 4 weeks. I have taken consent from the other party.
Okay. On the prayer of the learned counsel for the respondents. Mr.
Nabum Kaki. N. Kaki.
Mr. Swenso appearing on behalf of Mr. T. Tagal. List this matter after 4 weeks.
Interim order here.
Okay. Interim order was earlier shall continue.
Your Lordship, I would like to mention item number 23.
23. Okay.
The leading counsel is absent, so please adjourn the matter for 2 weeks.
Item 23.
Yes.
Who is absent?
R. Sonar.
Your matter. Item 23.
Oh, I was not informed. Sorry.
Oh, actually, I've been instructed by my senior. I thought they informed you.
The matter is a revision against order of the district court. We have already filed affidavit. So the matter will be listed for admission.
Okay. You are only one respondent.
Yes. Lordship, sorry, Lordship.
Eco Dumping Forest Development Society and another. There
Two
are
respondents.
you are appearing for all.
For all the.
Okay. Mr. Your name?
M. Khambo.
And Kamo, Learned Counsel, appearing for Mr. Arsona, Learned Counsel for the petitioner. Submits that his senior has some personal difficulty today, for which he prays for 4 weeks, 3 weeks,
2 weeks.
2 weeks.
Oh, so it's
MS
3 weeks. Sorry.
3 weeks.
Yes.
MS and Dungan Learned Counsel appearing on behalf of appearing for respondents. Submits that she has already filed a counter affidavit. Prayer for adjournment is allowed. List this matter after 3 weeks
Lordship.
for admission hearing.
Yes, Lordship. Okay.
Obliged.
Yeah, Your Honor. Then I'd like to mention item number 20.
20.
For the for the petitioner, Your Honor.
Hmm.
The service report of the respondent number 2 is returned unserved, so we may be allowed to take fresh step.
Orders we'll see. This order column we'll see. You wait for your turn.
Obliged, Your Honor.
Item number 1.
Sir, what is this?
May I please, Your Lordship? Lordship, the civil division petition, my lord. My lord, against the impugn order passed by the village authority, my lord. My lord, what happened in this case?
After the civil court acts, there is no provision for appeal.
My lord, here only thing is that since the same subject matter is already pending before this honorable court by way of writ petition, lordship, and writ petition in the same subject matter is sub judice, my lord. In that writ petition, my lord,
No,
the same.
that cannot be ground for filing and revision.
My lord, what
If there is a statutory appeal provision, you will have to approach the request to
my lord,
them.
difficulty is, my lord,
And does that
admittedly, my lord, civil revision.
if the similar matter is pending in a writ proceedings,
Writ proceeding, my lord.
you will file an appropriate application there also.
My lord,
But ultimately, wrongly or rightly, whatever, the decision is taken by the
Village
village authority. So appeal lies.
appeal lies, my lord.
When the appeal lies, where is the question of revision?
My lord, here the appeal, this is, my lord, one way of other proceedings. My lord, what if the two LPCs were cancelled?
It's okay. That is the subject matter in the before the writ court.
Writ court, my lord.
So either you file an appeal, or you may bring the notice, file an appropriate application in the writ court. See, problem is there is a statutory appeal provision.
My lord,
You will have
admittedly.
to approach that.
My lord, in as per
Is
my lord,
there or is there not?
my lord, it is also not that
After this,
clear.
no, after civil court act, there is an appeal provision.
My lord, it is also not that much clear by
We'll
provision.
make it clear.
My lord-
Let us see the civil courts act
My lord,
amendment. Latest amendment. What is the provision? Is there or is there not?
my lord, it is not that only the proviso, by proviso it has been given, my lord.
Whatever.
But in strict sense, so my lord, it is not given that the appeal where it has to be lies. Only the
That is,
proviso,
what is that provision?
my lord.
Provision. You are for?
On behalf of
So you are appearing for respondents.
yes, Your Lordship, the standing council is currently up to this in Your Lordship.
Standing council.
Yeah, 2014. Therefore, Your Lordship, I have been.
What's the question of it's a private dispute? What's the question of standing council? He's not a standing council, he's a sitting council. Huh? Why are you saying that he's a standing council?
Then corrected.
That's it.
Section 3 proviso, my lord. Otherwise, the provision for appeal is section 15. But by way of this amendment, my lord, only
Which provision?
the second provision. Yes, provided that in some other court, my lord, it was my respectful submission. In some other related cases, this is the only procedures when transfer is made, my lord. The directly appeal is not lies. It should be before the village or inter village customary court. This is only in respect of my lord when transfer is made specifically. The statutory provisions, my lord, has to be the appeal against the village authority has to lie before the so and so authorities, my lord. That should be the, my lord, exact wording of the, my lord, the appeal provision.
No,
But here,
let us see the principal act.
principal act, my lord, the first one, my lord.
15.
It is also there, man. Principal act, man. I've enclosed the copy, my lord. It is in the same, my lord, punch, which my lord is perusing, my lord.
Next one.
First one,
15.3. Let us see 15.3.
first one, first page. Earlier it was district session judge, civil judge. District judge, sorry, madam. But by this amendment, my lord, it has been made to the, my lord, again.
It depends on the pecuniary jurisdiction.
My lord.
It could lie before the district judge.
Again, there is
also.
another notification, my lord, wherein the above, if it is 20 lakhs, the jurisdiction has been conferred to the, my lord,
Civil judge.
civil judge senior division.
Senior division. So
That
what is
is-
the value of your?
And that in that case also, that is again contrary to the, my lord, one of the case where I still remember, Bengal, Agra, the civil X, wherein pecuniary jurisdiction is also hosted, my lord, to the even district judge.
No, that will not override. That Bengal Agra, before the enactment of the Civil Courts Act, the state, that may have some relevance, but after the enactment, so that will not have any application.
Yes, ma'am. In one case, what exactly the present situation is similar.
According to you, Deputy Commissioner or the village authority doesn't have the jurisdiction. That is what you are trying to point out in this writ petition, revision petition.
Civil revision, yes, my lord. Village authority, they have, my lord. As per the, my lord,
No, if it is not your case that the village authority doesn't have the jurisdiction to try and decide the matter, then you have to file an appeal.
my lord, as per the,
And it
Some-
provides that in case if the appeal is filed merely on the technical ground or procedural lapses that interest that should not be dismissed.
my lord,
So
admittedly, my lord, that provision is, my lord, in respect of, my lord, my respect.
so you file it
my
in
lord,
respect of in case if appeal is filed against the village authority or the customary courts.
my lord. But my lord, the provisions which I
See,
relied,
law is very clear. Unless your challenge is to the very root of the jurisdiction of the village authority or the customary court, no revision lies. If you say they have the jurisdiction, just because the related matter is pending before the writ court,
record, my lord.
that will not debar you from filing an appeal,
True, my lord.
which is recognized
But my lord, what,
statutorily.
my lord, what we are praying for is, my lord, under Article 227 of the Constitution, my lord, the supervisory power, wherein, my lord, when the error.
No,
and the-
for that's what I'm saying. For that, you have to say that the village authority ought not to have decided the matter because they don't have the jurisdiction.
True, my lord.
If that is not your case, can interfere.
My lord, again, my lord, what I'm, my lord,
See, basic the law is if there is a
my lord.
appeal provision or any other appropriate provision, statutorily, you cannot.
Therefore, my
26
lord,
or
it
227.
is my lord submission, my lord, just also for the, my lord, my lord, with the several rounds of discussions we are having with the law department, my lord, in this matter also, my lord. Now, another problem, my lord, there is no clear and the specific provisions for the appeal lies before the, my lord, the civil judge senior division.
No, by the Civil Courts Act, the pecuniary jurisdiction has
Right.
been fixed. Which court and what court? In that case, you file an appeal. If they reject it, then you may file a revision.
In principle, act, it is clear. Earlier it was district judge.
Hmm.
But by amendment, my lord, this third amendment,
Because of
Second
that,
amendment.
because of that pecuniary jurisdiction
my lord.
that has been fixed. So it depends on your value of your matter. Depends on the pecuniary jurisdiction. Could be civil judge, junior division, senior division, or district judge.
And in that matter, my lord, again, second amendment, my lord, there is no any whisper about the, my lord, the Bengal Agra Civil Court Act, my lord.
Not necessarily.
Again, my lord, by
That's
that,
why I'm saying Bengal Agra will not have an application now after the enactment of this Civil Courts Act.
Well,
The state has the competent, legislature has the competent to enact this law.
my lord, in one case, my lord, the jurisdiction has been hosted in the civil judge, my lord, district judge.
So
Very-
saying that this cannot
On pecuniary again, my lord, on
no,
pecuniary
this
jurisdiction.
Civil Courts State Civil Courts Act will not have an overriding effect
No,
to the
not
Agra,
exactly that,
Bengal
but
Agra?
my lord, not exactly that. Regarding my lord,
And I think that cannot be also.
yes, my lord, not exactly, my lord. Regarding jurisdiction,
Ah.
the civil district judge has no jurisdictions to take up the
What is the value of your your matter
my lord, as per
according
the
to you?
present proceeding, as per
Yes.
the record, it is above 2 lakhs.
You find it, then if it is above 2 lakhs, what is the jurisdiction of
But my lord, the present,
civil judge senior division?
My lord,
20 lakhs.
it is more than crore, my lord. Earlier it is 2 lakhs as per the, my lord, the pleadings. But my lord, as per the value of the land, if it is the assess in the market rate, present market rate, it is more than crore.
Well, then in that case, you can you not file before the district judge?
My lord.
Ah,
This is my respectful submission before
So-
your lordship.
you file a appeal in case if they refuse to accept whatever may be the reason, as you said, if there is no clear-cut provision, they may reject it also. They may say that then you come back. We'll see. Then we'll exercise the jurisdiction under 226, 227.
Now
Right.
urgency is, my lord, there is
Urgency, you have the pendency there. You may approach there also.
yes, ma'am.
We'll see. See, appeal. Immediately you file an appeal, ask for an injunction or whatever, stay of the thing,
Well.
matter and stay. So which cannot usurp the power of the civil court.
In that
Okay.
case, I may
In
be,
that case, you withdraw?
my lord, I may be allowed to withdraw with the liberty to file appropriate.
Yes. Mr. M. Kato, learned counsel for the petitioner, submits that he may be allowed to withdraw this civil revision petition with a liberty to approach the appropriate court against the decision of the customary public
Right.
village authority as per the provisions of law. Mr. The prayer of the land council, Mr. M. Kato is allowed. This petition is allowed to be withdrawn with a liberty as spread for.
Madam. Deeply.
What is this?
My lord,
Business rivalry?
my lord,
Business rivalry?
exactly, my lord. My lord, this is under misconception
We'll
it has
call
been
for the
filed.
city in the meantime,
Madam.
in the event of arrest. Or Mr. Titagum, learned counsel for the applicant accused, huh?
Yes, ma'am.
Applicant accused. And also her MS L. Hage, learned additional public prosecutor for the state of Arunachal Pradesh. This is an application under section 438 of CRPC, 1973. Praying for privilege of prayers bill to the accused applicant, accused oblique applicant, namely Indradis Malla, in connection with eternal PS case number 264 of 2023 under section 120 B public 406 409 420 IPC. Call for the case there. Next paragraph. Pending production of case diary, in the event of arrest, the accused public applicant Sri so and so shall be released on bail on furnishing a bail bond of rupees 20,000
My lord.
with with surety of like a month to the satisfaction of the arresting authority on the following conditions. The accused applicant shall cooperate with the investigation. Next, the accused applicant shall not tamper with the evidence. Then third, and the petitioner accused applicant shall not leave the jurisdiction of Itanward PS case without the prior permission of the
My lord.
investigating authority. This after 2 weeks,
Deeply applied.
Huh?
No,
Any date? 23rd.
deeply applied.
2 weeks. It's not 23rd. Then make it 1 week.
Yeah.
Then also 29 also.
29. Listed. It's on 29. 11. Yes. BC. Yes.
Yes, Lordship, 439 application, Lordship. Lordship, this is the NDPS case, Lordship. Last 53 days, Lordship, I'm behind the bar, Lordship. And in this case, Lordship, one of the co-accused is already in bail, depending upon the length of detention, Lordship. Lordship, on page number, Lordship, 17, there is an FIR, Lordship. And on page number 18, Lordship, is come on the first part, 8.5 grams, Lordship, is recovered from the car, Lordship, and 0.8 gram from the house, Lordship, from the death accused, Lordship, who is already in bail, Lordship. This comes from the intermediate quantity, Lordship. The penalty pays 60 days, Lordship. The humble submission, Lordship, already 53 days I am behind the bar, Lordship.
It's okay. We'll call for the CD.
Lordship is already 50, length of detention, Lordship, 53 days,
Doesn't
Lordship.
matter. What is the mandatory period? It's 180. NDPS.
No, Lordship, 60 days, Lordship. This come 60 days, Lordship. Already 53 days in there, Lordship.
Okay, we'll see. We'll see the case there. Okay.
Yes, Lordship, another accusation depending upon the length of
It's okay. Heard Mr.
N. Dubey, Lordship.
N. Dubey, learned counsel for the applicant accused. Also heard Mr. G. Taro, learned additional public prosecutor of the state. Next decision application, so 439, huh?
Court
Of the Court of for granting of bail to the accused public applicant who is in the custody since 23/9/20.
23/9/23.
Yes, in connection with Alops case number 62 of 2023 under section 22 within bracket small b bracket close oblique 27
A.
within bracket a small a bracket close NDPS Act. Call for the case diary. This is better after when you can.
Lordship, on 53 days already is there, Lordship. After 60 days is our mandatory period, Lordship. So within that period, Lordship.
Then in that case, you file an application. But this is the section is 22B and 27.
Yes, Lordship. Yes,
And
Lordship.
then-
The panel is it may be extended to 10 years, Lordship.
No, you on the next date you try to find it out. It's not simple as you are trying to project. Okay.
Lordship, a short date, Lordship.
After 10 days. When do you want?
Lordship,
After 10 days. PP is saying after 10 days. We'll consider on that day.
Lordship,
this matter- this
after 1
matter
week,
of-
Lordship. After 1 week, Lordship, hardly request, Lordship. 1 week, Lordship. 1 week, because already mandatory.
Make it 9 days. 9 days is what? After 9 days.
9 days, Lordship.
Yes, which 9 days? List this matter after 9 days. That is on so and so and you. Okay. Now.
Highly obliged, Lordship.
May I please, my lord?
What is this? That
My lord, this is a bail application.
APPSC.
Yes, my lord.
We'll call for the case diary.
Yes.
Same order. You find it from here. 439 application. In connection with CBI case number RC01 1720 22A 0009 within bracket original FIR number 229/2022 under section 120 within bracket capital B /406/409/420 of IPC read with 7/8/13 within bracket 2 bracket close of the PC Act 88. Call for the case diary. List this matter after
My lord, may I fix on 17.
17. Can you? 17, can you?
On Monday, 20.
20.
No, 20.
What is the ground?
My lord,
Why you are seeking bail?
my lord, this,
Just because the main accused has been
yes.
granted
Yes.
bail by the.
yes, my lord.
No, every accused has a different ground to.
My lord, may I fix on 22nd.
22nd, I will be looking for on 20 or
17.
after 23 madam.
You want me to
20.
list the matter on
24,
2020.
20. Yes.
20, 11, 20, 20.
Deeply obliged.
My lord, this is a bail application under 439 of CRPC in connection with Itanagar PS case number 93/2023 under section 376 IPC read with section 4 of FOCSO Act. My lord, accused person was arrested on 20.
Same order. All for the case that you mark her your name also. Her Mr. So-and-so. Orin Modi, no?
Yes, my lord.
And also her Mr. T. MS T. Learned additional PP. Arunachal Pradesh. Bail application under 439. CRPC. Praying for grant of bail to the accused. Accused, huh?
Yes, my
Issue notice to the respondent number 2. Mr. The one is counsel for the applicant, accused self. Take steps for services of notice upon respondent number 2 within 2 days. Respondent number 2 by registered post with AD within 2 days.
Your lordship, if I may, your lordship, respondent number 2, the complainant actually is a different person, you know. Lordship will come to
Informant
page
is
number 21.
page
21, your lordship.
Page 21.
Yes, lordship. It's the father of the victim.
Okay. Why not the informant?
My lord, as per FIR, informant is the mother.
Huh?
As per the FIR, informant is the mother.
Oh, yes.
No,
Yes.
page 21 it's no,
Above, yes, your lordship, above that.
it's okay.
Yes, yes.
Then it's call for the case then. List this matter after 2 weeks.
My lord, may I 22nd.
Any case,
My lord, because PD Nair will leave this case, so he will come on to 22nd.
whoever comes 376. When you were arrested?
22nd.
26. No, when you were arrested? When you were arrested?
My lord, 25/9.
Okay. 22nd.
Yes.
List this matter on 22nd, 22/11/2020.
Deeply.
I will.
Case diary, huh?
Yes.
Call for the case. Sir, what is this?
This is compounding of non-compoundable offense.
Yes.
Settlement, this application has been filed on the basis of settlement arrived in between the.
What is the offense? What is the offense?
At least the offense is lordship. Kindly see section 341, 354, 354A, 323, 506. 354 is non-compoundable, and the rest of the 354, 354A is non-compoundable. And rest of the offense are compoundable.
Let us see the FIR or church sheet.
Kindly see, Lord.
What is the stage?
Stage
of the
is,
trial.
already stay order has been passed.
No, stage of proceedings.
Like appearance.
Proceedings
Appearance.
stay.
appearing.
It was at the initial stage, it was for appearance, your lordship.
Hmm.
Thereafter, the
Yes.
case was stayed.
Appearance, beginning of the trial.
It's not that serious. Is it? Are you opposing?
No, your lordship, since on the last occasion, the council was directed, since it's a joint petition, your lordship, the
Yes.
council was directed, because there was no signature, there was an issue of signature. The
Ah.
council was directed to, if your lordship will see the IA which has been disposed of, your lordship,
Yes.
was directed to file an affidavit by the second petitioner stating that she has no objection if the criminal proceeding is squashed, your lordship. Thereafter, they have filed this affidavit,
IA.
IA.
What is the IA?
IA.
Who has filed that?
I have filed that.
Then you file it.
Yes,
No,
I
they
have,
had filed
that-
it.
That is actually, this petitioner number 2. There's a lady
Let-
complainant has
let-
filed I, saying that I do not have any complaint if the matter is disposed of.
No, what we're trying to say is, since respondent number 2, I mean petitioner number 2, or
Yes.
the respondent number 2.
Yes.
Petitioner
Petitioner number 2 has in fact, via this affidavit, has made no objection if the proceeding has been quashed, your lordship.
Ah,
Actually, nay.
have you filed the affidavit?
I'm the petitioner here.
No, that's you are director.
I'm the petitioner. Both are the joint petition it is.
No, that's what I'm saying. The court has passed that petitioners are directed to file an affidavit.
This
By
that
a
is
second
with regard to
petitioner.
petitioner number 2.
Yes,
Yeah, that I have filed.
where it is.
The same.
This is
your-
the one.
This is the
Yes,
one.
Okay.
that I have filed.
So,
I don't have any objection, otherwise,
no objection.
yes.
No.
okay, dispose of. Well recorded, huh?
Yes, your lordship.
All right.
This is a pre-arrest bail lordship.
Hmm.
This honorable was pleased to grant me pre-arrest bail on 15/9 of 2023.
15/9.
Yes, lordship. This is a civil in nature, they have given a criminal court lordship. And today the honorable court wanted the updated CD of the case. As per the direction of this honorable court, by the order dated 8/11/2023,
Hmm.
we have sent WC message to the concerned PS, but
You
There-
have not received the latest status. Have you received it?
no, not this.
Since you are
Because-
abiling the.
Since then,
Is-
if lordship, even then lordship, this matter can be disposed of because this is a lordship and civil in nature. This is a
No,
criminal
there is interim.
lordship. Yes,
Interim
oh,
You have not been, you have been released on bail
yes, lordship, I'm released on them.
after the interim order.
Yes, lordship.
It's okay, we'll see the latest. When do you want? After a week,
Yes, after.
Mr. G. Tado, London Additional Public Prosecutor submits that he is yet to receive the latest status of the
Yes,
case for which he pressed for and granted 1 week time to
1 week.
obtain the latest status of the matter. Latest status of the case. Interim order passed earlier shall continue.
deeply obliged. Obliged.
May it please your lordship. Your lordship, this matter has become infructuous, your lordship, because the main case wherein the learned court below has directed for registration of FIR, that has been partially, your lordship, interfered by this honorable court. Here in the POCSO proceeding, your lordship, there was an allegation that the witness has been threatened by the present applicant. However, Your Lordship, without complying the procedure, which is the subject matter of the criminal petition, the learned court below has directed for registration of FIR under section 195A of IPC.
What is the status? of this?
Your Lordship, the investigation has been stayed, Your Lordship. Because on the strength of this observation, Your Lordship, the FIR was registered. And
Where did this say that?
Your Lordship, they have annexed, Your Lordship. This
Considering the semi-similar
it has been put in court and court, Your Lordship. From the above material available in record, it is found that there is criminal conspiracy amongst three so and so for threatening and deterring victim witness so and so from deposing evidence against accused so and so. Such threatening and inducement of victim so and so is evident from her deposition as PW1. Hence, it is observed that the said Siring so and so are involved in commission of criminal conspiracy and threatening of the victim for adducing false evidence before this court. As such, offense under section 120B read with 195A IPC are attracted against the above person. Hence, it is ordered that the OCPS Tawang shall register a police case under appropriate section of law and conduct investigation and submit a final report as provided under section 173. So, Lordship, this portion, because of this observation, Your Lordship, the FIR registered, and this court has stayed this particular, Your Lordship, observation made in the order by the learned court below. Because
against whom the bail has been
yes, Your Lordship.
sought for.
Yes, Your Lordship. Yes, Your Lordship. Now, investigation has been stayed, Your Lordship. So there exists no apprehension, Your Lordship.
Where is what do you say?
Yes, Your Honor.
What do you say?
Your Honor, as per this order, Your Honor, this present petition is infructuous. So this matter may be disposed of, Your Honor.
Mr.
N. Kaku for the petition.
Learned counsel for the petition. And also had Mr. T at the Learned Addition to the Police State of Arunachal Pradesh. The Learned Counsel for the parties jointly submitted that the bail application has become infructuous in view of the order passed by this court on 9/11/23 in criminal petition 205 of 2023. In view of the above, this bail application still closed.
Deeply obliged.
May your Lordship.
Yes.
Lordship, this is a NDPS bail application. And two conditions of section 37 of NDPS 1985 has to be satisfied, Your Honor. Number one is that satisfaction of PP by giving adequate time. Number two is on the satisfaction of the court that there are reasonable ground for believing that accused are not guilty, Your Lordship.
Yes.
Your Lordship, in this matter, what happened is, Your Lordship, the alleged accused person, they're from Longsam village who are Kani Edik. Almost all the area of that Longsam village, they are Kani Edik. Your Lordship, herein the alleged accused are the villager. As per the advice of his son, and as per the advice, as per the request of their family member, they went to Dibrugarh, Your Lordship, and for treatment and for de-addiction of their opium drug addicts, Your Lordship. There they met the doctors. They met a doctor at Dibrugarh, and the doctor duly prescribed the medicine for them, which is Adenox N-X, the seized substance, the alleged substance, Your Lordship, that was seized. Your Lordship, and then this seizure was also done in a very in a very manner, Your Lordship, which is not bit understandable, Your Lordship. Here, what happened is that as per the FIR, the informant is the OC of the Longding PS police station. He himself is the OC of the Longding PS. Your Lordship, then he said that as per the FIR, he received information that some person are coming with narco substances, drugs, by Dibrugarh to Longding at around 20 hours, 30 minutes. Then he called up his team, and then he reached at the spot at around 21 hours, Your Lordship, within 30 minutes of his pen, Your Lordship. All his team was ready within 30 minutes, which is 2 kilometers away from the place of where the seizure was done. Your Lordship, now I have a more than reasonable grounds for seeking this bail, Your Lordship. In this regard, Your Lordship, may I take Your Lordship to annexure number 4 of my petition, bail petition. Annexure number is page 37, Your Lordship. Yes, the alleged accused at the very instance, Your Lordship, are medical patients, drug addict, Kani addict, yet they are medical patients. Yes. Your Lordship. They were arrested after visiting their doctors. Here in Your Lordship, in annexure number 4 onwards, Your Lordship, this is for Panay Wangpan, Your Lordship, the parts bail applicant. The alleged accused, Your Lordship. Panay Wangpan, he is advised, Your Lordship, to take 3 times Adenox N per day, Your Lordship. Here, his advice, and then gradually reduced to 1.5 to ultimately become nil, Your Lordship. In this regard, I have personally talked with his doctor, Your Lordship, and he has informed me that this 300 means for 3 months, Your Lordship. They were prescribed a medicine to procure medicine for 3 months as per this legal and legitimate medical documents, Your Lordship. Meaning thereby, Your Lordship, as per my calculation,
you are an addict.
Yes, I am an addict.
So for treatment, you have to take this Adenox.
Yes.
Medicine.
Yes, Your Lordship.
And which has been seized from your possession.
Actually,
drugs or something different?
Yes, drugs are different, Your Lordship. Actually, this is medicine.
This is medicine?
Yes, as per my version, and because this is duly prescribed by the doctor.
What is their version? What drugs they have seized from you?
They are saying that since I am in possession of this Adenox N, and this Adenox N, as per the NDPS Act, Your Lordship, in serial number 69 or 169, Your Lordship, this is a buprenorphine. This is a banned substance. If I possess that without any medical prescription. But then, Your Lordship, the case herein is that I possess this along with medical prescription by
there is no dispute.
Yes.
To the seizure of these drugs.
Yes, there is.
Whatever
No. In this regard also, Your Lordship, dispute is that 1,710 tablets were seized. But as per my alleged accuser concern, Your Lordship, the actual drugs they carried was 710 tablets, Your Lordship, which was seized from the middle row of the Scorpio in which they were traveling, Your Lordship. And that was that we admit that was the medicine that we carried. But again, while searching, they have found 10 more packets. Within the 10 packets, there comes 10 strips. 10 into 10 is 1,000 tablets were seized from a alleged tube, which was seized from behind they are alleging that it was seized from the back of the Scorpio car. But we are saying that that doesn't belongs to us. That was somehow, I don't know how it might have been planted, or it might have been, that is best known to the investigation team, Your Lordship. Now, even if we assume that 1,710 tablets it belongs to us, still then, Your Lordship, under this prescription for 6 person, Your Lordship, entire 710 tablets comes within the legal prescription, Your Lordship. So I was coming to that, Your Lordship. So as per the prescription, Your Lordship, Panay Wangpen was Wangpen was legitimately, as per the prescription, or legally allowed to, as per the prescription, he should consume 258 tablets within 3 months. And then Ngaju Wangpen will consume 252 tablets. And then Jongam Wangpen will consume 393 tablets. Nazang Wangpen will consume 168 tablets. Pantai Wangpen will consume 504 tablets. Wangling Wangsu will consume 252 tablets as per the prescription, Your Lordship, for 3 months spent. Since they are villager, they come from long way, and they are a daily wager also, Your Lordship. So now their total doses prescribed by the doctors totals to 1,827, which is, as per their seizure, it is 1,710, which is 117 tenths lesser than the prescription of the doctor, Your Lordship. Therefore, if we assume that all the 1,710 seized drugs belongs to us, still then that comes under the prescription of the doctor, Your Lordship. Therefore, what I am submitting is, Your Lordship, as per the NDPS Narco Drugs and Psychotropics Act 1985, Your Lordship, as per Section 8 itself, Your Lordship, may I take Your Lordship to Section 8? Yes, Section 8, Your Lordship, is prohibition of certain operation. No person, I will read to subclause C, Your Lordship. Prohibition of certain, no person shall, I will directly read sale, possess, Your Lordship. Possess, produce, manufacture, possess, sell, purchase, transport, warehouse, use, consume, import, inter-export, or psychotropic substances. Then thereafter, next page, Your Lordship, except for medical or scientific purpose, and in manner and to the extent provided by the provision of this act, or the rules or orders made thereunder, and in a case where any such provisions enforce any requirement by way of license, permit, or authorization, also in accordance with terms and conditions of license, permit, or authorization. Your Lordship, as per this NDPS Act itself, Your Lordship, as per Section 8, possession of narco drug substance which is prohibited as per the table, if it is possessed with medical or if it is possessed for medical or scientific purposes, Your Lordship, it is, Your Lordship, permitted. And thereafter, Your Lordship, may I take Your Lordship to Narco Drugs and Psychotropic Substances Rule 1985. Narco Drugs and Psychotropic Substance Rules. This is, earlier one was Act, Your Lordship. This is Narco Drugs and Psychotropic Substance Rules 1985. And as per the rules 66, Your Lordship, possession, etc. of psychotropic substances. No person shall possess any psychotropic substances for any purpose covered by 1945 rules unless he is lawfully authorized to possess such substance for any of the said purposes under this rule. Number 2, notwithstanding anything in any research institution, hospital, or dispensary maintained or supported by the government or local body or by charity or voluntary which is not authorized to possess any or any person who is not so authorized under the Act rules may possess a reasonable quantity of such stuff.
Where you are reading?
This is, Your Lordship, Narco Drugs and Psychotropic Substance Rule.
You also will find a page number 92 of the Act, Bare Act.
Yes.
It's Rule 66.
Yes.
Yes, Your Lordship. Rule 66, Your Lordship. I was reading number 1, then straightway number 2, clause number 2, Your Lordship. I will read 1, 2, 3, 4, the fourth line, Your Lordship. Or any person who is not so authorized under the 1945 rules may possess a reasonable quantity of such substance as may be necessary for their genuine scientific requirement or genuine medical requirements, or both for such period as is deemed necessary by the said research institution or the case may be. Provided that where such psychotropic substance is in possession of an individual for his personal medical use, the quantity thereof shall not exceed 100 dose units at a time. Your Lordship, thereafter, I am coming to your Lordship 67A. 67A, subclause C, your Lordship. A narcotic drug and psychotropic substance may be supplied or dispensed for use to a foreigner pursuant to medical prescription only from the authorized licensed pharmacies, etc., your Lordship. This I am reading, your Lordship, that if even a foreigner is having a medical prescription, he can acquire or he can possess that narcotic substances, even though it is a ban, your Lordship. Usually all the narco substance banned are like medicine itself, your Lordship. And if we, and thereafter, your Lordship, may I take your Lordship to, since this...
Whether your that possession exceed 100 unit doses?
No, as per my instruction, as per my telephonic conversation with the doctor, he said that he has even given the statement also that he has kept in view the everything whatever the prescription that needs to be done. So he said that it is legally prescribed medicine. Therefore, he has he said that he understands these rules.
No,
and
that's what I'm saying. Whatever she has, the doctor prescribed and which was seized from you.
Yes.
Is it below 100 doses units?
Yes, your Lordship. As per monthly calculation, it is below, your Lordship. It is below, your Lordship. And moreover, your Lordship, it is below 100 doses, your Lordship. And your Lordship, in this regard, again, the drug or narco substance seized, your Lordship. If they are seized, here, your Lordship, as per the, there is an exception, your Lordship, in here, as per the Narco Drugs and Substance Act 1985, your Lordship, Section 80 says, application of Drugs and Cosmetic Act not where the provision of this act,
which
Section 80, your Lordship, of Narco Drugs and Psychotropic Substance Act 1985. Here it says, your Lordship, the provision of this act or the rules made thereunder shall be in addition to and not in derogation of the Drugs and Cosmetic Act 1940 or the rules made thereunder, your Lordship. This says that as per this, your Lordship, Narco Drugs Substances Act, when it deals with the drugs and cosmetic rules, which govern the medical practitioner, medicine, registered medical practitioners, when the duly prescribed prescription that is being prescribed by registered medical practitioner, your Lordship, then in that case, this NDPS narco drugs will not override. Rather, these drugs and cosmetic rules need to be looked into. And as per this drugs and cosmetics rule 1945, your Lordship, drugs,
according to you, as per Section 80, what do you interpret?
Your Lordship, as per Section 80, what I want to interpret is, your Lordship, that the drugs or the medicine, that the alleged drugs that they have seized are medicines, your Lordship. And as per the Section 80, your Lordship, Drugs and Cosmetic Rules 1945, as per Drugs and Rules 1945, doctors are entitled to prescribe medicines which are prohibited by the Narcotic Drugs and Psychotropics rules, your Lordship, if required, Lord, as per the disease or as per the ailments, your Lordship. So, as per this Drugs and Cosmetics Rules 1945, which governs registered medical practitioner, your Lordship, in Schedule H, your Lordship, the alleged drugs that they have seized is buprenorphine hydrochloride, your Lordship, is listed, your Lordship. Meaning thereby, your Lordship, the medicine which was seized is like is a valid medicine, and that has to be looked in the angle of medicine, not as a drug substance, your Lordship. That is what, your Lordship, I am trying to project, your Lordship.
Because it is in addition and not in derogation.
Yes, your Lordship. And in this regard, your Lordship, I have a citation also, your Lordship. Citation is Your Lordship, Rajesh Kumar versus Gupta versus State of Uttaranchal, Your Lordship. Your Lordship, in this regard, in this case, Your Lordship, a doctor was FIR was lodged against a doctor under Section 8 and Section 22 of NDPS, or Section 22 of NDPS, Your Lordship. Herein, Your Lordship, the doctor was selling a kind of drugs which was prohibited under the psychotropic NDPS, Your Lordship, Act, and he was selling it by through postal, Your Lordship. In this regard, bail was moved in the special court, Your Lordship, which was, Your Lordship, which was rejected. Thereafter, he moved the bail in the High Court, Your Lordship, and while moving then thereafter, Your Lordship, High Court granted bail to the accused, Your Lordship. Then by special leave petition, Your Lordship, Your Lordship, this special was moved, Your Lordship. Special leave petition was moved, Your Lordship. Wherein here, Your Lordship, in page number 4, page number 4, the application of Section 37 and application of rule of NDPS 1985, etc. were discussed, Your Lordship. May I take Your Lordship to page number 3, Your Lordship? Second paragraph, Your Lordship.
Which this
Page
judgment-
3, page 3.
This judgment.
Yes, Your Lordship. It may be mentioned that it may be mentioned that public prosecutor is given due opportunity to oppose the bail and is heard at length. Now this court has to satisfy if there are reasonable ground for believing that applicant accuses or is not guilty of such offences as mentioned in Section 37, and if he is not likely to commit any offence while on bail, offences under Section 8 of NDPS Act 1985 is punishable under its Section 22, Your Lordship. Section 8 prohibits the possession and sale of narco drugs and psychotropic substances except for medical or scientific purposes, and in the manner and to the extent provided by the provision of this Act or rule, Your Lordship. Then thereafter, Your Lordship, learned counsel for the applicant urged that Section 22 is not section this. Your Lordship, then I am coming to third para, Your Lordship, the relevant portion. Learned counsel for the accused applicant urged that the drugs chlorphenidaz oxide and phenobarbital were being prescribed by the qualified doctors in the clinic of the applicant for medical purposes, and as such, no offense against the accused applicant can be said to have been made out under the NDPS Act. It is further argued that the drugs recovered were Schedule H drugs and the applicant has falsely been implicated in the case. No final opinion can be given on this issue as it would affect the trial, but for the purposes of bail, it is sufficient to mention that the applicant is a registered medical practitioner as Ayurvedic doctor, but he had no license to prescribe, store or sell the banned drugs, that too in such a huge quantity, Your Lordship. Then thereafter, Your Lordship, this 7 onwards, paragraph 7 onwards, Your Lordship, I will read the view of the court, Your Lordship, learned Supreme Court, paragraph 8. In above circumstances, this court is of the view that applicant has made out the case for bail. Learned Advocate General relied and referred the case of Collector of Custom versus Ahmedabad, Norida, 2014, SCC 834, and argued that expression reasonable ground mentioned in Section 37 means something more than prima facie grounds. I have gone through this case, said case. In the said case, accused was intercepted at airport with the banned drugs and she was not a medical practitioner. Therefore, for the reason as discussed above, the bail application is allowed and applicant shall be released on bail on following condition. He shall furnish case security of 1 lakh before the trial court and furnish 2 security bonds each of the like amounts to the satisfaction of this of trial court. He shall cooperate in expeditious trial. In case he causes delay in trial, the prosecution will be at liberty to seek cancellation of bail granted to applicant. He shall not leave India without permission. He shall furnish the undertaking that he shall not run the clinic, prescribe allopathies, etc. of the bail, Your Lordship. Your Lordship, in this case, same applies to my case also, Your Lordship. My 21C, 22 is also for C involves where the contravention involves commercial quantity, Your Lordship. My case is also a commercial quantity. And herein, Your Lordship, the doctor was prescribing the banned substances in the form of medicine, Your Lordship. And in the form of banned substances, Your Lordship, then, but the learned court has found out that when the banned substances are prescribed and are being issued for medical purposes, that can be considered, Your Lordship. And in my case, Your Lordship, I am inside jail since last 75 days, Your Lordship. And moreover, this, Your Lordship, I don't have any criminal antecedents, Your Lordship. Earlier, Your Lordship,
this is by which High Court?
This is by, Your Lordship, Uttarakhand High Court, but this is special leave petition is dismissed, withdrawn. However, petitioner would be liberty to. Your Lordship, this is.
You first be sure, this is a judgment of High Court or the Supreme Court?
This is Supreme Court, Your Lordship.
I'm sorry.
Yes, SLP was.
Make yourself clear.
No, Your Lordship.
You have downloaded it from, printed out from Supreme today. It doesn't mean it's a Supreme Court case.
No, Your Lordship, the state appeared before the Supreme Court. They have challenged that the bail granted by.
This order is by the High Court. Is it by the Supreme Court?
Yes, Your Lordship. This is by the Supreme Court, Your Lordship.
What do you say?
Yes, Your Lordship. In fact, this Rajesh Kumar Gupta, Your Lordship, if I may come to the facts of Rajesh Kumar Gupta's case, Your Lordship. Rajesh Kumar Gupta, in this case, what was exactly dealt was that any mixture of a natural substance along with the substance which is barred under NDPS law, if that mixture is to be taken into, Your Lordship, the weight which has.
No, this order is by the High Court or Supreme Court?
This is by Supreme Court, Your Lordship. I have.
Subsequently, Your Lordship, if that is even by the Supreme Court, Your Lordship, I also have the judgment, Your Lordship, which was later on overruled.
No, this is by the High Court or Supreme Court?
I'm not sure because I have a judgment of Supreme Court, Your Lordship.
Give it. This is Rajesh Kumar Gupta.
Yes.
Yes.
There is State versus Rajesh Kumar Gupta, which was the state had challenged it before the Honorable Supreme Court, which was later on overruled by Sanjeev V. Deshpande, Your Lordship. This, even Rajesh Kumar Gupta was overruled, even if it was by the Supreme Court, Your Lordship.
No, this order is by the High Court of Uttarakhand.
This is by the High Court.
Bail was granted. Against that was probably the state might have filed an SLP. The copy which you have read out,
yes,
is by the High Court when the accused was granted bail.
An application for bail was made by him along with the High Court. The High Court was responsible. Your Lordship, but however, Your Lordship, even if this is the case of High Court, Your Lordship.
No, I'll come to that.
Yes.
I just wanted to know.
Yes.
I wanted you to be clear yourself.
Yes, yes.
That the judgment and order which you have relied, is it by the High Court or Supreme Court?
File an application.
There is a mention of SLP.
Yes,
in the order. which you have, they have withdrawn. But it doesn't mean that
Somewhere, your lordship, I have read this is the state.
there
have
may be
appeared-
other cases
Yes,
by the Supreme Court, but the copy which you have placed on
yes, your lordship.
is not a Supreme Court order.
Yes, just now I have printed it from bar room, your lordship.
Huh?
Yes, while coming back, there might have been some
It's the
erroneous.
Supreme,
High
Uttarakhand
Court, High Court, High
Single
Court.
bench.
Single bench.
Honorable Purpula C. Pant. Same petitioner
Same
which you
petition.
are relying.
Yes, your lordship.
Against this order,
Against this order,
state has filed an SLP.
yes, your lordship.
Then,
However, that was overruled by Sanjeev.
no, what does it say in that SLP?
You
Supreme
lo-
Court allowed,
Yes, your lordship.
dismiss the SLP.
It has dismissed the SLP.
Ah,
Your lordship will see that the main issue with regard to that was with the weight of the combination of the drug. If the drug, some of the drugs are written in the schedule, your lordship. If there is a mixture of the drugs, how do we weight? Because if we weight it together, it contains the natural substance as well as the drugs that has been barred under the schedule, your lordship. Now that was the main point with regard to both Rajesh Kumar Gupta as well as Sanjeev V. Desh Gupta, your lordship, where later on the Honorable Apex Court has clearly held that the mixture, the combination of both the mixture, the weight of the combination of the both mixture has to be taken while weighing the to decide if the contraband, it has to be small quantity.
what is saying that whatever has been seized from him
Yes.
or her is a permissible quantity, which is for medical purpose only,
Yes, your lordship.
medicinal purpose,
Yes, your lordship.
which has been duly prescribed by the
Yes, your lordship.
doctors.
Yes,
Therefore, this cannot be contraband,
yes, your lordship.
even if it's seized from him. That's why I'm asking as per the rules, whether it is exceeding 100 units, doses.
No,
per
your
unit,
lordship.
or it is below.
Yeah, it's below, your lordship.
So what
The
he's saying
doctors-
is not a contraband at all. You cannot
Yes.
have booked under the NDPS. That is what is some.
Doctors are, your lordship, medical practitioner. They knows what doses needs to be given to the patient, your lordship.
If he can satisfy us, that it's not a contraband, it is for medicinal purpose only.
Yes,
Yes.
Then
yes.
we may.
I'll come to that, your lordship, if my friend has.
Yes. Your lordship, in this case,
That is your only case.
your lordship, here in page number 2 of my
Anything else?
yes, submission, it says that, your lordship, it appears that thereafter press bail application was moved before the trial court and the same was again dismissed by the
Let
search and
us not go into that dispute.
your lordship, it says that
Still, you are not sure whether this is a.
no, your
Supreme Court,
lordship,
High
I am
Court
sure
judgment.
this time
This is not a High Court, Supreme Court judgment.
Yes, SLP number 3/2005 appears to have been filed before the Supreme Court by the state on the basis of which criminal appeal number was registered. Honorable Apex Court in said appeal passed the following order, your lordship. This somehow has this case.
Connection
in
with
my-
the Supreme
yes,
Court.
your lordship.
There were
I am
two.
not asking.
Oh.
They have some other SLPs or whatever.
And
What I am asking is the copy which you have
yes, your lordship.
placed. Whether this is the judgment of the order of the
Yes.
Supreme Court or the High Court.
Yes, your lordship.
Not
that,
yes.
That I have to.
Yes or no? Not
No,
only yes. Is it a Supreme Court order?
No, your lordship.
Then you are saying that it's a Supreme Court order.
I am deeply obliged, your lordship.
Huh?
Deeply obliged. Your lordship, I am coming to my conclusion argument, your lordship, my prayer.
So
Your
you are
lordship-
relying on the judgment.
No,
of
no,
the-
no, your lordship.
You are
No.
relying on the judgment of the order of the Honorable High Court of Uttaranchal.
Yeah, no, your lordship.
You are not relying.
No,
Why you are not relying?
your lordship.
You have read 3
yes.
paragraphs, and then
Yes.
now you are saying that you are not relying.
Your lordship.
Have you understood?
Yes, I understood you.
What I am asking is, you said it's a Supreme Court judgment.
Yes, your lordship.
I said, is it a Supreme Court order or judgment or the High Court's order? Simple.
Yes, your lordship.
Not yes, whether it's a yes or no.
As far as my reading, it seems it's High Court judgment, your lordship. Now,
No, it seems you have to be
It,
very sure.
yes, it is High Court judgment, your lordship.
See, I'll tell you, reason, very
Yes.
simple reason.
Yes, sir.
The order or the judgment of the Supreme Court is binding.
Yes,
On all the courts, including all the people in the
Yes.
country.
yes,
But the High Court may have a persuasive value.
yes,
It's not binding on other high courts.
yes,
That's the reason I'm asking.
yes, Your Lordship.
At the first blush on it is not a Supreme Court, High Court. Maybe you are mistaken that it is, you have drawn got it from the Supreme today.
Yes, Your Lordship. Somehow, my.
So this is a Supreme, not the Supreme Court order.
Yes, Your
It's
Lordship.
a order of High Court of Uttaranchal.
Yes.
Alright.
Yes, Your Lordship.
So
So,
you are relying, not relying?
I'm relying this to substantiate my case, Your Lordship.
It may have a persuasive value,
Yes.
but it's not binding on this court.
Yes, Your
That is
Lordship.
what I'm pointing.
Yes, Your Lordship. Your Lordship,
But Supreme Court, it's binding.
yes, Your Lordship. Your Lordship,
I may agree with this, I may not agree with this.
yes,
So it's not binding.
yes,
It may have a persuasive value.
yes, yes,
That you have to understand.
yes, Your Lordship.
That is the reason precisely I'm asking. It's a, you are trying to, I mean, impress upon that this is a Supreme Court order.
Yes,
Alright.
yes, Your Lordship.
Anything else?
Yes, Your Lordship, what I was submitting is, Your Lordship.
These are the medicine.
Yes.
Whatever you have purchased.
Yes.
As per the doctor, prescription of the doctor.
Yes.
It's a permissible, I mean, medicine for the medicinal purpose only.
Yes.
It's not a contraband.
Yes.
So
So it is a more than reasonable grounds to grant bail, Your Lordship. Moreover, they are behind the bail for no fault of theirs, Your Lordship. Even if trial proceed further also, Your Lordship, there is a high chance that this is to that since they are already furnished the medical prescription, etc., Your Lordship.
But
So conviction is
I have a different view on the reasonable ground
yes,
that you will not commit an offense again while on bail.
yes,
Because you are, I mean, sorry to say that addict,
yes, Your
you
Lordship.
may.
Yes,
That is the reasonable ground which the court has to look into.
yes, Your
Read
Lordship.
that provision, section 37.
Yes, Your Lordship. Section 37, notwithstanding anything clause contained in Code of number A, every offense punishable under this act shall be cognizable. No person accused of an offense punishable for offense under section 19 or section 24 or section 27A, and also for offense involving commercial quantities shall be released on bail or on his own bonds. The public prosecutor has been given an opportunity to oppose the bail for such release. Where the public prosecutor opposes the application, the court is satisfied that there are reasonable ground for believing that he is not guilty of such offense and he is not likely to commit any offense while on bail. Your
Two
Lordship.
conditions.
Yes, Your Lordship. Your Lordship, they will not commit again, Your Lordship. They are villager on the request of their family members only. It is a tradition in their area to consume take kani, Your Lordship. But then on the request of the family member only, they went to Dibrugarh for medical checkup in order to leave this and moreover, Your Lordship, they are already in the jail for 74 days and they are the only.
This is the ground.
Yes.
My question is in custody or for 75 days.
No, Your
Can the
Lordship.
bail should be
But Your Lordship, I am seeking for leniency. Moreover, Your Lordship, they are head of the family and they are
Is
the.
it a commercial quantity?
Yes, it's.
Assuming that.
Yes, it's commercial quantity, Your Lordship, and they are the head of the family member, and because of them being inside the jail, Your Lordship, entire family is suffering. Your Lordship. That's it, Your Lordship.
Anything else?
No, Your Lordship.
No other judgment.
No, Your Lordship.
She has the.
Your Lordship, actually, it was very hard for me to find judgment in this regard to section 21 because obtaining of bail is very hard in this case, Your Lordship. But then I have a very strong reason, Your Lordship, because I myself have also talked with the doctor, Your Lordship, in order to confirm so that I may not mislead this honorable.
So would you like to have some more time to find out the judgment?
Your Lordship, I have tried it, Your Lordship, since this has been 33 days already. Every day I am trying to find because I have to do justice with my clients, Your Lordship.
Your Lordship.
Yes.
With
You have
regard
the
to
CD.
yes, Your Lordship. With regard to the statement, Your Lordship, first of all, that there is no bar is that the OC cannot file a FIR against any person, Your Lordship. Secondly, Your Lordship, is very unfortunate, Your Lordship, there is a bail application being moved, Your Lordship. However, there is a contact with the prime witness, who is the doctor, Your Lordship. There is a conversation between and all the information with regard to with a witness, Your Lordship, in this case. Now, Your Lordship, if I may take Your Lordship to the FIR, Your Lordship, which is at page number 35.
35.
Yes.
Yes.
If I may read, Your Lordship.
Yes.
I'm to inform you that today on 28/8/23 at 2000 hours, a telephonic information received from sources that one vehicle, Scorpio white in color, bearing number so and so, carrying manufactured psychotropic substance, is reportedly coming towards Longding from Assam via Kanubari. Accordingly, ADS team accompanied by so and so Longding and Executive Magistrate Sri so and so conducted Naka check at Longding Kanubari Highway below so and so village. During Naka checking, the suspected vehicle was stopped by at 20-30 hours, and accordingly search was conducted in presence of the executive magistrate. And the same manner, a notice under section 50 NDPS was served to the person on board to be searched in presence of the magistrate. However, no incriminating substance was found from their body or their possession. Meanwhile, on further search of the vehicle, psychotropic substance, that is adonic, and 10 packets containing 100 numbers of strip was found, which was hidden inside the tire tube. Your Lordship may take notice of this. Tire tube kept at the back of the vehicle, and open and loose adonic and 71 strips hidden inside cube tray kept on the passenger seat in the middle row of the car. Accordingly, the entire manufactured drug was weighed and found 359.1 gram approx, and later seized on the spot in presence of the executive magistrate and the driver of the car. Further, it is found at adenoid and comprised of brufen and nadoxine comes under the purview of NDPS case. Now, Your Lordship will see if any patients go to any medical practitioner, get a medicine, Your Lordship, that will be under his position, not kept hidden inside a tire tube, Your Lordship. Now,
that is the reason your colleague is avoiding reading the FIR.
Yes, Your Lordship.
You should have started from the FIR.
Your Lordship, actually, the medicine substance which was kept in the tire tube, we deny that doesn't belong to us. The main portion I have already submitted.
Is it a car you are traveling?
Yes, I was traveling, Your Lordship.
You were traveling a car in this?
Yes,
you are traveling in this car?
Yes, Your Lordship.
Your car?
No, not my car, one of our relatives' car that has been released on Jimma.
What?
Yes.
Now, if I may, Your Lordship, the same submission that they denies, on one hand, they accept to the fact that they have gone to the medical practitioner, got the medicine, Your Lordship, and they were on their way, and they were subsequently, the police had arrested them for the offense, Your Lordship. On the other hand, if Your Lordship will see at page number 37, they're on annexures, Your Lordship. As per their statement, these are the prescription given by a doctor. Your Lordship will see there is no analysis. Only adenoic is there. Side below, Your Lordship will see 300 tablets.
When was this? There is 28/8, no?
Same day
Same
when
day.
they were arrested.
Yes.
Your Lordship will see 300. Next 300. Page number 39, 200 tablets.
My Lordship, this 300
Just
indicates
wait,
months.
Just wait.
Yes.
Let her
Yes.
complete.
40, Your Lordship. You'll see all these tablets were, as per their own requirement, were provided, Your Lordship. Now, if Your Lordship will see the CD, Your Lordship, I have flag marked the CD, Your Lordship. Now, all of these accused had gone together, Your Lordship, and the purpose of going together, all of them has given their statement, Your Lordship. If Your Lordship will see the first statement by the accused Nokai Wangpan, Your Lordship.
Is also the.
Yes, Your Lordship. He seems to be the main culprit, Your Lordship, in this matter. Next statement is of Manglang Mangsu, Your Lordship. Nokai Wangpan has clearly stated that he just went only to accompany his father. first accused, Nokai Wangpang has clearly stated that he has gone to Dibrugarh to just accompany his father. There is no mentioning of he has gone for any kind of medical checkup or not, Your Lordship. Now, Your Lordship will also observe that as per their own statement, they have stated that one stripe cost 100 rupees, Your Lordship, and they have bought it for 71,800. Next, Your Lordship will see Wanglang Mangsu. He has gone only to show the route to Dibrugarh because he had on previous occasion been to Dibrugarh. He has also not mentioned that he has gone for any checkup, Your Lordship. Now the third one, Panay Wangman. Your Lordship will see. Panay Wangman interestingly state that he has been paid to go along with the other accused, Nolai Wangpan, paid 100 rupees so that they gave them the adenoic tablet. Next, Your Lordship will see Panskai Wangpan. Even he stated that he has been given 1,000 rupees by Ngaju Wangman to accompany them to Dibrugarh to get the adonic tablet, Your Lordship. Now, all these accusers, Your Lordship will see the statement of all the accusers, none of them had gone exactly for their treatment or whatsoever, Your Lordship. All of them have gone there to get adonic. All of them has clearly stated they had gone there for adonic. Now, if a patient
Yes.
Your Lordship will see that all the accusers has gone to Dibrugarh only on the request of one or two accusers, Your Lordship. And they were paid to be to accompany them. And all of accusers, Your Lordship will clearly say, has clearly stated that they know that this is a drugs and they have gone there only to get the drugs. All the doctors.
Then come to the statement of doctor.
Doctor, Your Lordship. Now, even I have not xeroxed the this, Your Lordship. However, I have read the CD, Your Lordship. Will clearly see the doctor also does not. He does not get any.
He prescribed normally 100 tablets, and if it is from remote village,
Yes.
he prescribed 300.
Yes.
3 for 3 months.
3 for 3 months, Your Lordship.
300.
Yes, Your Lordship.
What was the quantity?
Quantity is 1,710, Your Lordship.
How many people were there?
There were 6 people, Your
All
Lordship.
of them are.
All of
They are,
them.
they are the applicant accused here.
Yes, Your Lordship.
Six persons. 6
Yes.
into 300.
Yes, Your Lordship.
Just multiply. I mean, the
1800, Your Lordship.
yes.
Yes.
Seized was.
Seized was 1000. 1010 tablet. 1710, Your Lordship.
And they admitting that they are addict.
Yes, Your Lordship. Now,
Doctor says.
yes,
For an addict patient, no protocol, no test is required.
yes, Your Lordship. Now I will come to that, Your Lordship.
Hmm.
If the statement of all the accused would have been different, Your Lordship. I'm a doctor, Your Lordship. If any person comes to me, Your Lordship, and say that this is my issue, I'll prescribe certain medicines, Your Lordship.
Hmm.
Now, therefore, was pointing right to the statement of all the accused, Your Lordship. All the accused has gone only on the instruction of some of the accused, Your Lordship. They were paid, and Your Lordship will see the statement of all the accused. They had referred that we went there only to get the Adonic, Your Lordship. Now, what is Adonic, Your Lordship? It's a combination of Brufen and Your Lordship will the other medicine. Now, Brufen under the schedule is a psychotropic substance, Your Lordship, which is barred under being a drug, comes under NDPS, Your Lordship. Now, any quantity of that, Your Lordship, doctor has to clearly state for how many months, how many tablets, and Your Lordship will see the proviso provided, Your Lordship.
The problem is why they have to kept it in the tube and pad. Otherwise,
Yes, Your Lordship.
if it is for your consumption
Yes, Your
as
Lordship.
a medicine, why you have to keep it? Why you have kept it in the pad or tube?
Your Lordship, that has to be decided during trial, Your Lordship, whether they actually kept it or not, who sees them, what was the exact ground, Your Lordship. And moreover, the statement given also needs
But
to
this court wants to know why.
Your Lordship, that as per their version.
Because on the basis of your service, you say
Yes.
it's a medicinal purpose.
Yes, yes.
And if it is medicinal, why put it with you or in the bag or something else?
Yes, Your Lordship.
On the open in the car. Why have to hide it?
Your Lordship, what I have been instructed is that, Your Lordship, they have the numbers of the 710 was kept in the middle row, Your Lordship, and the tube portion. They said that they are not aware of it, Your Lordship, and that will be proved. However, even if all the
Your car and you are traveling in that.
yes.
Is your relative's car, whatever.
Yes, Your
You
Lordship.
don't know how
Yes.
who has hide it, who has put it there. This is something strange.
Yes,
It
yes,
cannot-
Your
this is beyond. I cannot believe that.
Yes, your
Yes,
moreover.
anything else?
Yes, Your Lordship. I would rely only on the statement of the accusers, Your
Yes,
Lordship. They has clearly said that they had gone only to buy that medicine, and everyone in the villages of that particular village know that pharmacy, that we get Adonic from that pharmacy. That's it, Your Lordship.
Your Lordship, here in what my
No,
learned
just
friend-
wait. And
yes,
anything else?
Yes, Your Lordship. Also, with regard to the doctor, Your Lordship, I have very clearly stated on my beginning of my submission that unfortunately, though he being a witness, there has been a clear communication by the accused counsel and the witnesses, Your Lordship. That can be.
Then what about those judgment which he has relied?
Yes, Your Lordship. In fact, if I may, Your Lordship, this judgment was later on. This was with regard to issue of the mixtures and the substances, Your Lordship. The weighing, how do we weigh? Do we calculate the entire total mixture amount or not, Your Lordship? Which was subsequently, Your Lordship, was overruled.
Where's the paragraph? Relevant paragraph.
Now dealing to the point of cosmetic, the drugs under NDPS and Cosmetic Act, Your Lordship, that was dealt with.
This has been overruled.
Yes, overruled by
Saying what?
Your Lordship, the issue dealt with was regard to the drugs in the schedule of the Cosmetic Drugs Act as well as the drugs under NDPS. This was mainly of the import and export of those drugs, Your Lordship. The drugs contained in the schedule of Cosmetic Act would be barred by the NDPS, the drugs under schedule of the NDPS Act.
also your lordship will see that if they are making a submission that with them there were only 71 strips of 10 strips of tablet that was found, your lordship, and the rest of that is not aware, your lordship. The rest of the tablet has been found from the same car that they were traveling, your lordship. If that is so, that was also in excess of whatever the medical prescription as per their statement, your lordship.
What is the investigation, stage of investigation?
We are still, your lordship. In fact, though the statement of the doctor has been taken, your lordship, there is further investigation to that effect also, your lordship.
But the tablets comes under the purview of NDPS.
Yes, your lordship.
Yes.
What is this request for medical expert opinion?
Yes, your
About the
lordship.
drugs? I mean, the medicine?
No, it's not yet.
No, what expert you want? What opinion you want?
Because, your lordship, that adonic is a combination of certain drugs, your lordship. That has to be first, the ingredient has to be first examined by the expert, and then a clear concept of what exactly the drugs contain of has to be decided, lordship.
I find it to be a medicinal purpose.
No, your lordship. If your lordship will see Brufen, your lordship will see that the Brufen is normally.
No, it may comes under NDPS, but the quantity
Yes, your
which
lordship.
you have seen
Yes,
in
your lordship.
their position.
Yes, your lordship.
6%.
Yes, your lordship. That's why I'm saying.
100 strips, you paid 1,100. Say, supposing. if
1,710, your lordship. Your lordship, therefore, I'm stating that they are completely denying that the other tablets were seized from their vehicle, your lordship. They had in their possession under the hidden
Maybe
tray.
purpose of some other, I think they might.
Yes, yes, your
Okay.
lordship. Therefore, and also the statement of all the accusers, your lordship. They are well aware that Adonic is the one.
Yes.
And also that they were paid to visit the doctor along with the other accusers. your lordship. Yes.
Your lordship, actually, I was, this is printed out from indiankanun.com. Actually, I was to submit this, this is indiankanun.com. As per this, your lordship, this is State of Uttarakhand versus Rajesh Kumar Gupta, the earlier one, your lordship. Herein, bail was moved at the special court in regards to 377 and matters and all. Then it was dismissed. Then before High Court, they moved it, High Court granted it. Then the state moved a special leave petition for recalling it. Then there was an order for reviving of the then High Court was requested to dispose the again bail expeditiously. Then bail was allowed. Thereafter, the state moved before Supreme Court under 136. This was the citation, your lordship, actually. The printed out, the earlier printed out was from Uttarakhand.
She has given.
Oh.
According to her, this has been overruled by the subsequent. You know Sanjeev Deshpande?
Yes.
Let me go through this. Do you have the copy?
Your lordship, I'll print and give it to you.
Yes. Your lordship, and in regards to one statement of the accused, your lordship, alleged accused, Noklai Wangpan, whatever he was stating was right, your lordship. He was the only driver, your lordship, and as per the doctor prescription also, there is nothing. He was the driver, and the alleged that Scorpio used for that purpose. He was the driver because he knew the Dibrugarh, and they were his relatives and his elders here. Therefore, he took them to the medical, your lordship. Moreover, whatever the 1,800, and the seized drugs were 1,710, Your Lordship. And this Adenox N, as per the Central Drugs Standard Control Organization, Your Lordship, as per them, this Adenox N is used for for drugs addict, Your Lordship, for detoxification, Your Lordship. There is no conflict about it, Your Lordship. That's it, Your Lordship. Therefore, Your Lordship, this Honorable Court may grant the rights, Your Lordship.
We'll see. I'll examine and pass the orders.
Yes, oblige, Your Lordship.
Item 10 to 15.
10 to 15 are the same matters. Yes.
Yeah, Your Lordship.
Yes.
Lordship, this is an application playing for the regular bail of the alleged accused who has been arrested in connection with New Delhi PS case number 94 of 2023, Your Lordship, under section 306, that is abetment to suicide, Your Lordship. So the alleged accused person has been arrested on, the FIR was lodged on 9/10/2023, Your Lordship. The FIR relevant page, Your Lordship, that copy is in page number 16. Fine, Your Lordship.
Page
16, Your Lordship.
16.
Is the type copy, Your Lordship. I am to inform you that late Dangi alias Eliza Fangcha, 19 years, daughter of so-and-so, resident of so-and-so, is found hanging inside the rent house opposite to Fort Tiller Lekhi village. As per the reliable source, Sri Taro Liak Sonam was boyfriend and he used to torture her anytime for the reasons he committed suicide. The torture witnesses were Soping Rabe, Miss Chupi Pasang, Miss Onisa Fachang, Nabam Natung, Mama Den were the friends of Dangi Fachang who can tell you detailed story. Her mobile number was switched off on Friday 6/10/2023 at 11 p.m. onwards. Then the parents started searching her, and while searching, brother of Taro Liak, mobile number so and so, found the dead body first hanging inside the rent room. Therefore, I would like to respect you to register a criminal as per the law and arrest Taro Liak Sonam, who is behind her death, and investigate thoroughly as per the laws. This is the FIR, Your Lordship. So this FIR has been lodged on the basis that because the alleged accused person and the deceased were in a relationship.
I apologize. I went for washroom. I went up for washroom. I apologize.
Do you have the CD? How many days in the custody?
Your Lordship, he was arrested on 10. So as of today, he's 34 days, Your Lordship.
34 days.
Yes, Your Lordship. So, and the reason behind also, if Your Lordship will see, that is in page number 23, if I may take Your Lordship. The page number 23, that is annexure 2A.
Sir, are you ready? Do you have the CD? Cash ready?
Yes.
If not, we'll take up tomorrow. Page
23, Your Lordship. Annexure 2A. In this, the alleged accused person, he was not arrested, but he surrendered before the police officer, Your Lordship. And the reason why, Your Lordship will find in page number 23, reason for arrest. It has been mentioned that the alleged accused, namely Sri Taro Liak, is mentioned by name in the FIR for abetment of suicide. So there is a danger to his life from the victim's side if he is not arrested. That was the reason he was arrested and put behind the judicial custody as of today, Your Lordship. And also, if Your Lordship will see, he has been cooperating with the investigation because on the date of his arrest itself, 161 statement was recorded. That has also been mentioned in the page number 23, prayer for reason and therefore. The physical interrogations of the alleged accused person is completed. So is being forwarded to Honorable Court for further judicial custody, Your Lordship. So as of now, the investigation on his part is completed. He's in custody since 10th of October, Your Lordship. And the only reason he was arrested, he himself has surrendered before the police because there was a threat to his life, Your Lordship. Because the allegations has been put against this alleged accused person because they were in a relationship. Not that there is evidence, Your Lordship. So FIR has been filed only alleging that they were in a relationship and he might have been the reason why he have committed suicide, Your Lordship. That is the reason why we are before this Honorable Court praying for enlarging him on bail, Your Lordship.
Yes, Your Lordship. Yes, per FIR,
this accused person is specifically, his name was mentioned.
No, it's okay. It's been more than 30 days.
Yes, your lordship.
35 days.
34 days as of.
34 days. What
Yes,
is- do you
306 IPC is punishable extended up to 10 years.
It's okay.
So, mandatory period is not yet over.
Not necessary. Why you?
Because your
why
lordship,
you put why you arrest them? Why you put them in the custody or the judicial
because
custody?
your lordship, the investigation is still
What is
pending.
the reason?
Investigation is still pending.
What pending?
Lots,
It's a 306. You have interrogated him. Any further interrogation is required?
to unearth the
You
truth.
show us from the CD whether any further interrogation is required.
No information, but analysis of CCTV and mobile phone.
When did you receive this CD? What does it say? Anything here?
Yes, here accused is implicated by all the prosecution witnesses, 7 prosecution witnesses. He often threatened to hurt or kill the deceased, mentally tortured, being a married man, he had a physical relationship with the deceased.
Forget it. You just tell us whether his interrogation is required or not after 30 days.
Interrogation part is over, right, Your Lordship?
Huh?
Interrogation part is over.
Then what do you want? Before conviction, can it be punished?
But investigation has yet to unearth the truth, more specifically from the some digital evidences. It is also fact that no any suicide note was found from the spot. It is also fact. And door was locked from inside. Suicide it is quite clear about the death of deceased. But threatening was pointed, all the witnesses were implicated, these accused persons, for giving constant torture, mental tortures.
Lordship, to my humble understanding, when a bail application is filed,
It has to be considered the fact that he has been cooperating with the investigation, Your Lordship. And all the details that whatever the witnesses has been pointing out, that will come in the later stage, in the trial stage, Your Lordship. So at this stage, interrogation, the part of the accused person has been completed. Long time, Your Lordship. That would be my humble submission, Your Lordship. And whereas the police himself, before the magistrate.
You obtain the status, whether the further interrogation is required or not. We'll take up on Friday.
If Your Lordship, small prayer, Lordship, prayer for reason and therefore in here itself, it has clearly been mentioned that it is the physical interrogation of the alleged person is completed.
Completed.
Yes, Your Lordship.
Whether further interrogation is required or not.
Yes, Your Lordship.
Yes. Friday.
Obliged, Lord.
Friday.
Also heard Mr. Jita, the learned additional PP for this. The learned addition next para, learned additional PP shall obtain the clear instruction as to whether the accused applicant is required for further investigation. List the matter on when it is?
Thursday or Friday, Your Lord. Thursday, sir.
Friday 17.
Sir.
17/11.
Obliged.
But practically, I think it's better UPDL.
Yes, Your Lordship.
Huh?
Yes. Much obliged.
Yeah, Lordship.
Yes.
Lordship, I beg to mention that in this case, the earlier respondent has withdrawn their wakalatnama on 15/12/2021, and after that, nothing has been shown in the cause list.
You are for?
Mr. Deepangan.
You have not taken press steps.
So, my Lord,
This
we humbly beg.
MS so learned constable petitioner submits that she may be allowed to take press steps. Praise the Lord. The learned constable petitioner is permitted to take press steps within 3 days. You take press steps.
Much obliged, Your Lordship.
Perhaps Your Lordship, service is completed, Your Lordship.
Service complaint.
Yes, Your
So
Lordship.
what should be done?
May fix for admission hearing, Your Lordship, because there is an stay by this court.
Non-APS petition. Mr. T at the learned additional public prosecutor submits that services have been completed. In view of the list is matter for admission hearing after 2 weeks.
Yes, deeply obliged.
Where is this, sir?
Please close. Yeah, close. As for last order, additional PP has to receive a relevant instruction.
Yes, sir. Yes, Your Lordship. If I may, Your Lordship, to point the factual metrics of this case, Your Lordship. The petitioner has challenged for non-registration of his complaint before the Deputy Commissioner, Your Lordship. If I may point out, Your Lordship, if Your Lordship will see the complaint, Your Lordship. It is at page number 50.
What instruction you are supposed to obtain?
Yes, Your Lordship.
Huh?
With regard to if this complaint, any cognizance has been taken against this complaint and this complaint has been registered or not, Your Lordship.
Okay. Page
Page number 50.
50.
Yes, Your Lordship.
Yes.
though we have given the order, Your Lordship, we have sent the order and sought for the reply, Your Lordship. However, the connectivity of telephonic connectivity of the area is in a bad situation, Your Lordship. We are not able to.
Grant another 2 weeks.
Yes.
Mr. So-and-so learned Conjurer's President. MS P. Dilly, learned additional public prosecutor, submits that she is yet to obtain the instruction as sought for on 4/10/2023. List this matter after.
No, so the interim may be
2 weeks, huh?
Interim given on last occasion. It may be
Okay,
continued.
interim order or what?
Yes, my lord.
Accordingly,
Yeah.
no, there is no.
There is no,
No,
there
so,
is,
interim order passed by the executive minister shall be continued.
There is no interim order, sir.
Yes.
there is no interim order. In fact,
Again, the instruction, it's a registration, I mean, what?
registration of the complaint.
Complaint, that's all. What's there? There's no interim.
No,
What interim we can pass? The nature of the prayer, there cannot be any interim. That's why we want that whether this has been registered, not registered, acted
Yes.
upon. We just want to have.
In
that.
fact,
Lordship,
the issue of
during pendency of this application, Honorable Executive Minister Howland has passed interim order directing that.
Where it is, where it is. I have not, I didn't find it. Where it is.
Lordship,
Go ahead, where it is. If it is not there, I'll accuse your cost. It might be in some other cases, some other case.
Lordship,
Find out from the court's file, not from your loose sheets.
Lordship, on dated 4/10.
Sir, please check out from the court record. Is there?
Lordship, it's not here, but.
So
as
from where you have obtained it. If
Lordship,
you have that thing, will cause an inquiry. Let me see.
Lordship,
Let me see. Your order, that your loose sheet.
Lordship, as for instruction given by my senior, yes.
Is this an interim order? This is by the executive magistrate.
Yes, Lordship. On, during the pendency of this case, executive magistrate has passed this in practice order. In practice order. Directing the respondent number 2 to not to operate his stone crusher.
So, what is the interim order of this court? Okay. No. The executive magistrate has directed the respondent to reply. And in the meantime, the crushing plant shall not be operated by the magistrate. And it's become infructuous.
Yes,
in that
Yes,
case.
infructuous.
Why you are you are said, in view of this
Yes.
order, your only prayer is for registration of your complaint.
Yes.
It has been, the magistrate has taken cognizance and then, accepted and issued a notice giving them an opportunity. And then crushing plant has been stopped, directed not to appear.
In that case, the matter is,
Mr. So-and-so learned counsel for the petitioner and also heard MSTG learned counsel for the learned additional PP for the state of Arunachal Pradesh. The learned counsel for the petitioner has placed an order dated 13/10/2023. Whereby the complaint of the petitioner has been on the complaint of the petitioner against the running of crushing plant. The executive magistrate has directed the respondent number. Who is that? Respondent number 1 or 2. Respondent number 2. Namely, Messrs. Bhartiya Infra Project to file a reply, not to file it, directed the so-and-so, respondent number 2, to submit a written reply. Written reply to the complaint filed by the petitioner. Please stop. The executive magistrate has also directed that the stone crushing plant of the installed by the respondent number 2 shall not be operated in the meantime. Please stop. Next one. In view of the above, this criminal miscellaneous application has become infructuous. The parties, the petitioner may pursue the matter before the appropriate authority, if so desired.
Lordship, at the time of
application
passing,
states-
we are not given any opportunity for her. They have passed the order without our presence. The order passed by the executive magistrate was,
You challenge that if you are agreed by the order of the executive magistrate. The present petition stays closed.
on being infructuous.
On being become infructuous. Do you have the extra copy?
Lordship, no.
You give one copy here. Okay. After Xerox. The copy of the copy, the order passed by the executive magistrate, the copy of the order passed by the executive magistrate.
Lordship, my prayer person will be kindly tell my prayer person, on last prayer person. Actually, my senior counsel has yesterday briefed me like that to place like this prayer.
This is what we have passed.
Okay, okay.
Sorry. It is repeated. You could have pointed
yes,
out
yes.
at the very outset that one. That is your prayer. You said interim order to continue.
I may also be provided with a copy of the order, Your Lordship.
You look like what's there? We're keeping it one.
Yes.
You submit one copy here and give it one copy to her. All right?
Yes.
So it's closed now.
Yes.
All right.
Deeply offended.
Actually,
How long you have been in the practice?
Lordship, actually, I was not regular. Sometimes I used to be in some other work. I used to engage in.
No, you make you this profession as a main profession.
Yes.
Other business that will go side by side. If you want to practice, be serious. Otherwise, off and on will not lead you to anywhere. Be serious.
Yes.
There's a reason why you are off and on. You are in a different business. Therefore, you are not able to catch up the procedure.
Yes, ma'am. Exactly.
You decide whether you want to practice. If you want to practice, be serious about it.
Okay.
Otherwise,
Your Lordship,
somebody made a mention this morning.
Your Lordship, as per the official note, the addressee was not found, Your Lordship. And addressee was not found. The respondent number 2, private respondent.
Address is not found.
Yes, Your Lordship.
You take a press step, huh?
Yes, Your Lordship.
Press steps.
Your Lordship, there are 2 addresses. 2 address pertains to the present
Let them find
respondent.
out and,
Yes.
Take a press steps. Heard Mr. So-and-so learned concept and also heard Mr. He at the learned additional PP for the state of Arunachal Pradesh. Office note, next para, office note reflects that office note dated 13/11/2023 reflects that the notice sent to the respondent number 2 has been received back answer with a postal note that the addressee is not found. Mr. In view of the above, the learned counsel for the petitioner to take press steps by placing the press steps within 2 days on the correct address of the respondent number 2. List this matter after 3 weeks.
Deeply obliged, Your Lordship.
Lordship, I am for the petitioner, the respondent there appearing for the first time.
Yes, I have appeared first time, and I may be given
Heard
some time
Mr.
for.
So-and-so, learned counsel petitioner. Mr. So-and-so. Dugong.
Yes.
Or Dugong, learned counsel for the learned counsel appears on behalf of respondent. Sole respondent.
Yes, Lordship.
Yes.
Respondent. List this matter after. When do you want? 2 weeks, 3 weeks.
3 weeks.
3 weeks for admission hearing.
Lordship, there is
For
an interim that may continue.
The interim order was earlier shall continue. Okay.
Right.
Criminal appeal.
Please, my lord. Yes, criminal appeal. Lord, service is completed. So let it be fixed for admission hearing.
What should be done today?
Your Lordship,
Receive
the LCR has been received, Your
LCR.
Lordship.
Paper
Paper
to
book,
be
Your
prepared.
Lordship.
Mr. So-and-so learned consequently appellant and also had MSTs in the learned additional PP for the state of Arunachal Pradesh. The LCR has been received. Mr. The registry to prepare the paper book. Then listed for hearing.
Hearing.
On completion, on preparation of the paper book. The copy of the paper may be served to the respective parties and thereafter list the matter for admission.
My lord, IA is also there.
What is IA?
IA for suspension and for bail till the disposal of the appeal.
Do you want to argue?
Uh,
You want
Not
to argue?
today. Next.
Your Lordship, just
After,
the,
after preparation and you'll be served and then it will be listed.
yes, yes, Your Lordship, prior to that, Your Lordship, if on the next date, if the applicant, if the respondent is not able to appoint any counsel, Your Lordship may appoint amicus curiae in that regard or from the
We'll see-
legal
we'll
aid.
see on that
Yes,
basis. Right.
after 2 weeks, Your Lordship,
After 2 weeks.
3 weeks.
3 weeks. Ah. Yes.
Obliged.
Huh?
Your Lordship, as per the
Same
office,
order.
no, Your Lordship, as per the office, not, Your Lordship will see that steps has not been taken by the appellant.
So, sir, take it.
My lord, there is an IA in this,
No, you take first step and then we'll consider. IA is for bail.
Yes.
No, we'll consider. You take a step since you have not taken a seat.
Your lordship may please to
This is your fault.
consider today.
Your fault. Huh?
Yes, in
No,
fact,
this is not the first time.
Since PP is there, your lordship may consider the IA.
12/10/2023. You have not taken the steps, sir. You take steps first, then we'll consider.
No, your lordship,
Heard Mr. S. Coing, learned counsel for the appellant, and also had MSTGD for additional, learned additional public prosecutor for state. Next para. Office note dated 13/11/23 reflects that the learned counsel for the appellant has not taken steps upon the respondent number 2 till then. List of the learned counsel for the appellant is directed to take steps for service of notice upon the respondent number 2. But registered post within 2 days. 2 days.
well, within,
3 days.
no, 1 week.
1 week.
No,
Then in that case, we'll have
After-
to list
after 2
after,
weeks, after
not
2
2 weeks. If you are taking the steps, we'll list it after 3 weeks. If you are taking the steps within 1 week, we'll list it after 4 weeks.
then I'll take a step out within 3 days.
3 days, list after 3 weeks.
2 weeks.
Because, no, because it has to return, no?
All
What's the, if after serving, if nobody appears, no issue. But once you take a step, 3 weeks.
All right. All right.
Conviction,
Conviction,
sentence,
10 years.
10 years.
10 years. Okay.
All right.
May I, Lordship?
What is to be done today?
This is a joint petition for quashing, Lordship, under section 482 of CRPC. May I, Lordship? Lordship, here the petitioner number 1, 2, and 3, they are the alleged accused. And the petitioner number 4 is the victim, and petitioner number 5 is the complainant.
What is the offense?
Offense, Lordship, it has been registered under section 341, 325, and section 34 of IPC. Also, as well as
You have
20.
not mentioned anything. 341, 302.
201.
The case is pending for appearance, Lordship. Case is pending for appearance in the trial.
Are you objecting seriously?
No, sir, no, sir, actually, yeah,
We'll
grievous,
hear-
injury is
in that-
grievous,
In that
Lordship.
case, we'll hear at 2.
Say, this,
At 2 will hear you.
Lordship.
We'll have to take lunch also. You think over it, are you seriously objecting it?
Lordship,
In
just,
view of the nature of the offense,
Lordship, because injury is serious, Lordship, this is, Lordship, grievous injury is there.
326.
Lordship.
But it's a joint petition.
Yes, Lordship. Since
If
Lordship,
it's joint petition, you want.
there is a counter FIR by both the by
Is
both the
there any,
parties.
let's say, judgment? If the injury is serious in nature,
just I'm-
compromise will not have.
Lordship,
But
just,
I have come across a Delhi High Court judgment.
No.
Even if it's compromised, Section 376 in POCSO.
Lordship, I'm not Lordship genuinely objecting, just I'm appraising the court, Lordship, just injury report is there.
Here you.
Lordship.
Lordship, give the-
छोटा मोटा चीज ना मैडम छोटा मोटा चीज क्या ऑब्जेक्ट since the medical expenses and everything were taken care by petitioner number 1, 2 and 3 that I have made a categorical averment also on that basis lordship everything in guidance of the elders and well-wisher lordship the settlement they had made
You are not concerned about 218.
218 lordship we are not concerned about that since lordship we have compromised everything that
But
also
will not mention anything.
yes lordship
Only we are concerned about 216.
2616
Yeah, where this has been charge sheeted.
yes lordship Lordship, deed of settlement, we have categorically mentioned in our deed of settlement that after the medical expenses and all the things has been taken care by petition number 1, 2 and 3. Lordship, they have compromised the matter and they are no willing to proceed with the case any further, Lordship. Since Lordship, the case is in its initial stage.
So charge sheet is has been while after the settlement.
Lordship, since they had made a settlement earlier, but
This settlement is of which is this 2022.
yes, Lordship, settlement, Lordship, is on to 22 or this 29th day of November 2022. But in our settlement also, Lordship, we had made a categorical statement that coming to Lordship, page 67. That is that will be number 3, Lordship. That is with Mary Donald. It says, Lordship, that after the family of the victim and the family of the second party, that is the accused and the victim, solve the matter amicably between them in presence and guidance of well-wisher and following elders on 28th September 2022.
When is the charge sheet filed?
Charge sheet has been filed on, Lordship, it's on charge sheet by 23/11 of 2022.
22.
Yes, ma'am.
After or before? Before the settlement.
Before, Lordship, as per Lordship, settlement was done before, but to facilitate to show this honorable court that we have settled the matter, we have executed this deed of settlement. But deed of settlement is on 29 November. That is after will be 6 days after the charge sheet is filed.
Yes, madam.
Lordship, as per the Lordship, the consider Lordship, this medical report, this is grievous in nature, but Lordship, if the both the parties has willingly and voluntarily settled the dispute lesser, then this court has the inherent power to interfere, Lordship. As the Lordship, as per the Lordship, record Lordship, LCR record, this case is still pending and is in the evidence, this appearance stage.
Appearance.
Yes, Lordship, appearance of this accused person, which is scheduled to be held on Lordship 12/12/23.
Which section is non-compoundable?
326, Lordship.
326. Okay, we'll allow.
No, it's a discussion of this court, Lordship.
Or Mr. Bijama, learned counsel for the petitioners. And also our Miss MS L. Hage, learned additional public prosecutor to the state of Arunachal Pradesh. Next paragraph. By filing this petition, are you comfortable? by filing this petition jointly by the petitioners under section 482 of CRPC, 1973. The petitioners have prayed for quashing of a criminal proceeding arising out of FIR dated 31/8/2023, registered as Itanagar PS case number 216 of 2022. And subsequent GR case number 730 of 2022. And section 341, 326, 201, 34 of IPC, 1860. Next paragraph. The facts in nutshell is that a complaint on 31/8/2022, a complaint was lodged by the petition number 5, the elder brother of petition number 4, alleging that on 30/8/2020 at around 9:50 p.m. at Happy Restaurant, Gandhi Market, Itanagar, the petitioner number 1, 2, 3.
Yes,
Huh?
sir.
Petitioners number 1, 2, and 3 with a sharp weapon, and as a result, had attacked his brother with a sharp weapon, and as a result, the petitioner number 4 had sustained grievous injury and admitted to the RK Mission Hospital, Itanagar. Accordingly, the case was registered as accordingly. The NFR was registered as Itanagar PS case number, being Itanagar PS case number 216 of 2023 under section 341, 326, 34, and subsequently charged it by dated 23/11/2022 under section 341, 326, 201, 34 IPC, 1860. Which is pending at the stage of appearance before the
JMFC law. Judicial Magistrate.
Judicial Magistrate First Class, UPR.
Yes, Lord. So Capital Complex, UPR.
Yes. Next paragraph. Mr. D. Jamal, counsel for the petition, submits that with the intervention of family members and well-wishers, the matter has been resolved and the petitioner number 1, 2, 3 had borne all the medical expenses of the petitioner number 4. Yes. The petitioners have also executed a mutual deed of settlement on 29/11/2022 before the executive magistrate, eternal. And resolved to settle the matter amongst the parties. Okay. German Learned Council to the Petitioners. Learned Council submits that. The petitioner number 1, 2, and 3. After attending the celebration of Salung Festival on 30/8/2022, visited the restaurant located at Eternal. And they sat down in the room where they have consumed alcohol. And in other cabins, some group of boys were also enjoying their drinks. During the course of making payment, the petitioner 1, 2, and 3 had some argument with the lady manager for charging exorbitant bill upon them. While negotiating the payment of the bill, all of a sudden, the petition number 2 pushed down the petition number 3. And for his rescue, petition number 1 came and challenged the petition number 2, and on being challenged by the petition number 1. For the petition number 1 and petition number 2 went outside the hotel in open space for a while in the process, both of them got injured. Since it was dark, no one could make out how the injury, how parties got injured. Next paragraph. He further submits that since the issue has arisen out of the argument between the manager and the petitioners, and on the intervention of which is the number 4 and 5. But there's nothing to show that there's any intention to harm or injure anyone by the parties. Rather, it was just out of the pitch of argument and sudden provocation. He further submits that be this as it may, the parties have entered into a settlement on 29/11/2022. On the intervention of the family members and well-wishers and solve the matter amicably between amongst themselves. For which the chance of conviction is bleak, and the trial of the case will be futile. Therefore, he submits that the FIR when is the FIR?
FIR is on page 20, Lordship. Page 20.
Page 20?
Yes, Lordship.
FIR dated 28 or 30?
So there are two FIR, Lordship.
No, that's 2016. I mean, 216.
Yeah. It's page 20, Lordship. The type copy is on page 20, Lordship.
0216 is page 21, Lordship. Type copy is on page 20.
8/2022, and the GR case and the proceedings of GR case number 730 of 2022, pending before the MFC, UPI, maybe question. Next paragraph. MS L. Hage, learned additional public prosecutor, submits that as per the medical report, the injuries or injury?
Injury, clinically grievous injury, Lordship. It is 47 page.
Injury is of grievous in nature, which clearly affects Section 326
Lordship.
of IPC. However, she fairly submits that in view of the settlement among the parties, this court may pass appropriate orders in accordance with law. Consider and pass appropriate order in accordance with law. Next paragraph. You remember that in the case of so-and-so, Madhya Pradesh was in Lakshmi Narayan. In the case of so-and-so, state of Madhya Pradesh versus Lakshmi Narayan so-and-so, reported in 2019 by SCC 688. About the Honorable Supreme Court, after consideration of the earlier cases, has enunciated the law regarding the settlement, regarding the washing of FIR, so-and-so, FIR, or the criminal proceedings under Section 482 of CRPC 1972. The relevant paragraphs are quoted here and below. Paragraph 15, 15.1, 15.2, 15.3, 15. You start from paragraph 15 and then 15.1, 15.2. Before that, you just, in the case of before that, I have considered the submissions of the learned counsel to the parties. And also, where is the scan copy?
Yes, it's can copy of the answer.
Where is the LCR? Used by the learned counsel. Then you write that in the case of so and so. This code, then next paragraph, after quoting them. Take note of the fact that no, not that. It is seen that the parties have entered into a settlement on 29/11/2022. And resolved the matter amicably amongst themselves. On the intervention of the family members, intervention of the elders of the families, respective families, and well-wishers. It is also noticed that the medical expenses of the victim, within bracket, respondent number 4.
Yes, Lord.
Has also been borne by the respondent number 1, 2, and 3.
Yes.
Respondent number 1 and 2. And they have decided to maintain the cordial relationship between the families as before. Next one. This code also take note of the fact that the fight among the between the parties erupted due to petty issues, namely argument regarding the bill, which may have caused some injury to the parties. As noted above, during the pendency of the proceedings, the parties have entered into a settlement and promised to maintain a cordial relations among the parties. This notice of the considered view that the FIR and the consequential proceedings, criminal proceedings, consequential criminal proceedings pending before the London JMFC. You write judicial magistrate first class, UPR. Maybe may end up in futile proceedings, as the chances of conviction are bleak in view of the facts situation of this present case. Accordingly, this court is of the opinion that this is the present case is one of the cases where the power under the inherent power of this court under section 482 of CRPC, 1970. Is fit to be invoked. Excellent. In view of the above, and the law enunciated by the Global Supreme Court, the FIR and the consequential criminal proceedings. FIR number so and so, and the consequential criminal proceedings being GR case number so and so. Remember GR case number 750 of 2022 under section 341, 326, 201, 34 IPC is hereby quashed. In the result. First, consequently, the consequently present criminal petition is allowed and disposed of.
Bibliography.
Yeah.